This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about the problem of sloth and failure to follow court orders and why that would require a court to dismiss a lawsuit. And because in the United States District Courts, failure to prosecute a suit requires dismissal, especially when the litigant ignores court orders. It must have its suit dismissed. In Kmart Corporation versus AIG Assurance Company, the United States District Court for the Central District of California on June 16, 2025, dealt with a suit by Kmart against its insurers for breach of contract and failure to indemnify in a different lawsuit. The proceedings encountered multiple delays due to Kmart's bankruptcy, resulting in a court-ordered stay. On October 25, 2018, the court issued a stay on the case pending the resolution of Kmart's bankruptcy with instructions for counsel to provide updates to the court. Kmart did not file timely status reports, with the last communication dated December 14, 2022. Consequently, the court issued orders for updates in May and June of 2025, exercising exceptional patience on the part of the court. The court evaluated 5 factors regarding dismissal for failure to prosecute, including the public's interest in resolution, management of the docket, potential prejudice to the defendants, and the availability of less drastic sanctions. Ultimately, the court dismissed the action without prejudice due to Kmart's failure to comply with court orders and prosecute the case, thereby closing the matter. On January 9, 2020, plaintiff filed a status report stating the Chapter 11 plan was approved, but no effective date was issued and thus the stay should remain in effect. On January 4, 2021, plaintiff filed another status report stating no changes had occurred since the last update. Since 2021, plaintiff has remained silent. The district court noted it is well established that district courts have sua sponte authority to dismiss actions for failure to prosecute or to comply with court orders. In deciding whether to dismiss for failure to prosecute or comply with court orders, a district court must consider 5 factors. 1, the public's interest in expeditious resolution of litigation. 2, the court's need to manage its docket. 3, the risk of prejudice to the defendants. 4, the public policy favoring disposition of cases on their merits. And 5, the availability of less drastic sanctions. The first 2 factors, public interest in expeditious resolution of litigation and the court's need to manage its docket, weigh in favor of dismissal. The failure to prosecute and follow court orders hinders the court's ability to move the case forward, disposition, and suggests plaintiff does not intend to litigate the action diligently. The third factor, prejudice against defendants, also weighs in favor of dismissal. The fourth factor, public policy in favor of deciding cases on the merit, ordinarily weighs against dismissal. It's plaintiff's responsibility to move toward disposition at a reasonable pace and avoid dilatory and evasive tactics. plaintiff did not discharge its responsibility, despite having been instructed on its responsibilities by the court, granted sufficient time in which to discharge them, and warned of consequences of failure to do so. Under these circumstances, the policy favoring resolution of disputes on the merits did not outweigh plaintiff's failure to obey court orders or to file responsive documents within the time granted. The fifth factor, availability of less drastic sanctions, also weighs in favor of dismissal. The court cannot move the case toward disposition without plaintiff's compliance with court orders or participation in the litigation. Plaintiff has shown it is either unwilling or unable to comply with court orders by failing to file responsive documents or otherwise cooperating in prosecuting the action. Finally, when dismissal should not be entered unless plaintiff has been notified dismissal is evident, the court noted that it had explicitly warned the plaintiff about the possibility of dismissal, and therefore the court dismissed the action without prejudice under Federal Rule of Civil Procedure 41B for failure to prosecute and comply with court orders. Kmart had sought damages from its insurers because of lack of defense or indemnity. That suit became an asset of the bankruptcy estate, which asset was either determined to be worthless or not worth the expense needed to even try to succeed. Rather than dismiss the case by the bankrupt estate, it did nothing and forced the United States District Court to dismiss the action for failure to prosecute. This video is adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 4, sometimes 5 or 6 a week. You'll receive access to the more than 5,100 blog postings. Please tell your friends and colleagues about this blog so that they can also subscribe. And if you watch on rumble.com or youtube.com, please click on the thumbs up button on Rumble or the like button on YouTube. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.